45 CO1 1303 PL16.
Good morning, Your Honor.
Good morning, Your Honor. Good morning. For the record, would you both identify yourselves and who you're representing?
Yes, Your Honor. Tracy Coleman for the Gary Community School Corporation.
Okay.
Yes, Your Honor. Christopher Hansen for the plaintiff, Von Sims.
We're here on this CRO injunction that we're here on. Counsel, is that what we're here on?
Correct, Your Honor.
Temporary restraining order?
Yes, Your Honor.
Are you objecting to it?
Yes, Your Honor.
What are you objecting to?
Your Honor, our objection is that there's no, they haven't submitted any affidavits or anything to support that a preliminary injunction is the appropriate avenue in this matter. As the representative of a governmental entity, when complaints come to us, they come to us through a tort claims notice under 34-13-3-8, and that gives us sufficient time to investigate the complaint made. And so in this case, instead of going through the process that's already established by law, they're circumventing it through a temporary, by seeking a preliminary injunction. And they haven't provided any basis to show that the Gary Community School Corporation is doing anything inappropriate or doing anything to destroy evidence or anything that we would deny that we're doing. And so at this point, Your Honor, they haven't provided any witnesses or any testimony that there's an emergency, that there's an opportunity for irreparable harm. And then on top of that, they haven't complied with the Tort Claims Notice Act, which would require them to serve us with notice regarding what their allegations are in order for us to properly do our job in our investigation. So based on the evidence that has been presented to the court, which at this point is none, as far as no affidavits, no witnesses, nothing to show that the Gary Community School Corporation is doing something illegal or unethical, we will ask that the court deny their request for a preliminary injunction.
Counsel?
Your Honor. I just had to address some of these points. As far as the tort claim notice, the tort claim notice does not require that we file it immediately. It requires that we file within 180 days, which we intend on doing. This is a preliminary approach that we're taking in trying to preserve this evidence. We don't have to allege that the Gary School Corp is doing anything wrong or illegal or that they're doing anything they shouldn't be doing. And we're not alleging that. All we're saying is that there's evidence here, or that may be here, and we want that evidence preserved. As far as there being no emergency, we have a client that is a special needs student who was raped. I consider that an emergency. There's an investigation being conducted by the Gary Police Department that's ongoing.
And Your Honor, I would just have to object for the record that he's assuming facts, not in evidence. He has not presented any witnesses or anything, but he's just testifying as an attorney.
An allegation of rape.
Right, and there's no evidence before the court, even in their affidavits. And that's where the tort claim notice is important for us to investigate the allegations versus just submitting them to court without proper form affidavits or testimony from witnesses. So we'll show our continuing objection to this.
If I can continue. With regard to the tort claim notice, the tort claim notice doesn't require the file notice to file a TRO. I don't know of any rule that requires that. As far as this being an allegation, we have a client with medical records showing that she was raped. She was at school at the time, and there is an ongoing investigation with the Gary Police Department. We have writing and confirming that from the Gary Police Department that there is an ongoing investigation. There's also newspaper articles about this. I mean, this isn't something that our client concocted, you know. And like I said, we're not asking or requiring them to produce this evidence. I don't know if it exists. We don't know. That's the problem. We don't know if it
What's the problem with preserving any evidence if it does exist?
Well, Your Honor, as he indicated that the school corporation has done nothing wrong. And the whole purpose of seeking a preliminary injunction is because there is a chance of irreparable harm.
Well, if the evidence is lost, wouldn't there be irreparable harm?
Well, Your Honor, One, as far our position is that when we seek a preliminary injunction, you have an obligation to produce the affidavits and the testimony to support the giving of a preliminary injunction, and then a court will be obligated to issue an order that outlines the findings and the conclusions of law. In this case, the only evidence is coming through an attorney, and not what's required by the rules, the affidavits, the testimony from the witnesses. So at this point, Your Honor, we're objecting to the manner in which they're proceeding, and that's the whole purpose of the Tort Claims Act.
I think what counsel's confused about is the whole point of the TRO is to try to preserve or to stop something because you don't have all the information that you need to ascertain what has happened. Here, we don't know what has happened. We don't have records from the Gary Police Department yet, and I don't know if any rule that requires that we produce our case before a TRO. That's the whole point of the TRO, is that we don't have all that stuff, and we just want to preserve it so that we can do discovery and let the case progress to its normal course. The problem is, as counsel makes my argument for me, is that the tort claim notice requires that they deny or approve the claim within 90 days. Until we get that, we can't file a suit on this. So you have 90 days there, plus the time that we file the complaint, issue discovery. I mean, it could be 6 months, right, from the time that we do that to the time that we actually get some of the information, if it exists, that we're seeking. And we don't know if these students are seniors. Are they graduating? Are they going to, I know a couple of the students were expelled for this. Are they going to be transferred to another school? Are they going to, we just don't know. And I don't know if their files are destroyed after a certain amount of time. I don't know if the video footage, I know most places, I know our own office doesn't keep video footage around for years. After 30 days it's deleted. And that's our concern, Your Honor, is if there's a video showing this or showing that it didn't happen, then that would resolve this whole, the whole case.
And Your Honor, we would just cite case law as far as City of Gary versus Enterprise Trucking, 846 Northeast 2nd, 234. And once again, it goes to the requirements and the obligations that they have to produce the evidence to the court.
What I have a problem with is why do you have a problem preserving evidence?
Your Honor, it's not a problem. The issue is
why are you reluctant to want to preserve the evidence?
Your Honor, the school corporation has rights as a governmental entity. And so on behalf of the school corporation,
plaintiffs have rights to this evidence, don't they?
If they want to assert their rights, Your Honor, there's a method that they have to follow, and that includes affidavits, that includes witnesses. This counsel is requesting a preliminary injunction without any witnesses, without any affidavits. So our position on behalf of the school corporation that at this time the court does not have sufficient findings of fact and conclusions of law to support the grant of a preliminary.
What kind of affidavit would they have to want to preserve evidence?
Your Honor, when you look at the Rule 65 and what it requires that they submit to the court the affidavit to support the granting of a preliminary injunction. When the court grants the temporary injunction, the court can go ahead at that time to grant it. But then the court has an obligation to set it over for a hearing so that counsel can produce the evidence.
This is a verified motion, isn't that more or less like an affidavit? Okay. A verified motion.
Okay, Your Honor, when we also go to what the rules require, and if I may, Your Honor, I would support, go to Trial Rule 65D, where it says that every order granting temporary injunction and every restraining order shall include or be accompanied by findings as required by Rule 52, shall be specific in terms, shall describe in reasonable detail, and that by reference to the complaint or other document. So they cannot circumvent their requirements by submitting a complaint which says all of these things.
A verified complaint.
Right, but they cannot rest on that complaint. They have an obligation to produce the witnesses and
what witnesses would they be producing?
Your Honor, that's the whole.
And Your Honor, the issue is
what witnesses would they be producing?
None, because the school corporation didn't do anything wrong to even justify.
Well, I don't think they're alleging the school corporation did anything wrong. They're alleging they want evidence preserved. because evidence on these tapes, sometimes they automatically erase.
Well, Your Honor,
If there are tapes.
and our position would be that
And
the
quite
court...
frankly, counsel, I've never seen anybody really object to it. Most people say, fine, we'll preserve the evidence.
Well, Your Honor, the issue is the school corporation will comply, and there's not, like he said, there's not any issue of the school corporation trying to destroy evidence or do anything inappropriate. And so that would make the need for...
Well, I don't think that's an allegation that he's making. I don't think he made that allegation that there would be anything inappropriate, just
We are not,
the fact that cognizant of the evidence, it exists and it preserves it.
And Your Honor, the school corporation, it will be our position that we do not need a preliminary injunction to tell us to do something that the school corporation in its course of business would do anyway, especially considering that they have not produced witnesses or affidavits to even support the giving of a preliminary injunction. So at this time, Your Honor, we would ask that the court dismiss it so that they could follow the procedures established by law with the Tort Claim Act to allow us to go ahead and do our investigation and follow the course of law as it is already said.
If I may, Your Honor, this petition for injunction is not in any way trying to circumvent the tort claims notice. We are completely cognizant of the requirement to follow those procedures. All we're trying to do, and as counsel points out, and admitted, what witnesses, what affidavits, that's the whole crux of our argument, Your Honor, is we don't have any of that, and we want to make sure that if it exists, that it's preserved. They have no requirement. I don't know of any law that requires them to preserve videotape evidence or particular records, investigation reports. She can sit here and say, well, we're not going to destroy it, but 6 months from now, when we're discovering, we're asking them to produce these documents, and they say we don't have it, then, what do we do? I mean, then we're kind of stuck there.
Then what remedy do they have?
That's the whole point of a TRO, is so that 6 months down the road, we're not stuck there with no evidence that could have otherwise been, ascertained and obtained.
And Your Honor, it would be our position they're not submitting any evidence or witnesses to say that we're destroying anything.
I don't think they're saying that you intentionally would destroy the evidence. But if it exists, just to be sure that it's preserved. I mean, you're dealing with employees, and things could happen. I mean, it could happen even with this TRO.
And it would be our position, Your Honor, the rules as far as what they're required to present, they have not done it. And so based on what the trial rules require, we will ask that the court dismiss their petition.
Your Honor, we've done dozens of TROs, and every single one, this is what we use as a verified motion. I don't know of any case or any trial rule that requires that we produce witnesses, and I've never seen it before.
I know witnesses you would produce.
That's our own client saying, and obviously that's what the verified motion. I mean, this isn't something that's been fabricated. We have a client with medical records showing that she was raped. We have information from our own client and her siblings that the students involved in this were expelled from the school.
And if I may, and that's even the more reason why they comply with the request for a preliminary injunction, even though they may have forms and do things that are routine, the rules are specific, that's what's required. And it's not the testimony of the attorney, but it's its compliance. And it also gives the school corporation notice of all of what they're alleging and what the allegations are. And so at this point, we would just request that the court dismiss their preliminary injunction because they have not complied with it.
Anything else?
All I can say is that we have complied with the rules. I don't know of any rule. We've done dozens of these before. I don't know of any rule that requires us to produce witnesses and affidavits. That's the whole point why we're here, Your Honor. And I think Your Honor realizes that.
All right, I'm going to find that I'm going to grant a temporary restraining order in order that the Gary Community School District preserve the evidence, and maybe you want to be specific as to what evidence you want preserved, if any exists.
If I may, Your Honor, I have a proposed order of injunction if you'd like to look at it.
Have you showed it to counsel?
They've seen it. We tried yesterday to send this to opposing counsel to get just an agreed so that we wouldn't
I
have to
would
waste the
object,
board's
Your
time.
Honor,
but-
to that line of testimony for the record.
Okay.
It's basically ordering that the same evidence identified in our petition be preserved until further ruling of this court.
Counsel, you looked at the order?
Yes, Your Honor, and my objection would be that this is not sufficient to comply with Rule 52, which requires the specific findings of fact, conclusions of law. They provided no evidence regarding any of these allegations regarding what they're requesting that the court order at this point.
All right,
So
you're-
that would be our objection.
Your objection is noted and overruled. All right, court grants petition in order.